Harlan predicted that as a result of the decision, of the civil rights case decision, we would not have African Americans taking their place as ordinary citizens, but a descent into discrimination. He wrote again, "Today it is the colored race which is denied by corporations and individuals, rights fundamental in their freedom and citizenship. At some future time, it may be that some other race will fall under the ban of race discrimination. If the constitutional amendments be enforced according to the intent with which they were adopted, there cannot be, in this republic, any class of human beings in practical subjection to another class." Well, as Harlan predicted, the one man, the southern states, which were now back in control of virtually every state government by virtue of the gains of the Democratic Party, they took the hint. It started with Mississippi in 1890, and by I think 1905, every southern state had drafted a new constitution, each of which made no mention of its intention to discriminate, but they inserted literacy clauses or property qualifications or grandfather clauses that would do the same thing. And I'm going to quote James K. Vardaman, who was later elected Mississippi's governor, and a United States senator who observed delicately. Again, the language is his, not mine. "There is no use to equivocate or lie about the matter. Mississippi's Constitutional Convention of 1890 was held for no other purpose than to eliminate the nigger from politics. Let the world know it just as it is." This was a public pronouncement. This was not at a dinner party. And yet the court still refused to see that the practical impact of their decisions were creating an atmosphere by which these kinds of constitutions could be passed and these kinds of statements could be made with impunity. And the results were everything the white governments could have hoped for. Black people were almost completely disenfranchised by the new constitutions. Louisiana passed a new constitution in 1898, and they kept very good records of their voters. On January 1st, 1897, the number of black voters in Louisiana was 130,000. By 1900, 2 years after this new constitution had been ratified, the number of black voters was 5,000. In every one of these cases, what the court was essentially doing was ruling that the 10th Amendment, the States' Rights Amendment, trumped the equal protection or the citizenship guarantees or the due process clauses of the 14th Amendment. But it turns out that the 14th Amendment was not just hollow verbiage. Once the rights of black Americans had been disposed of, the court took up the cause of a new oppressed class in America, the corporation. This is completely true. In a series of rulings in the late 1880s and on, the court struck down attempts by states to regulate commerce, even without any intention to discriminate. In other words, the test that they had set up for black Americans was not applied to corporations. Well, how can a corporation be granted 14th Amendment rights? It can. In order to do it, you just make it a person. And in Santa Clara County versus Southern Pacific Railroad Company, Chief Justice Waite asserted, "The court does not wish to hear argument on the question whether the provision on the 14th Amendment to the Constitution, which forbids a state to deny to any person within its jurisdiction the equal protection of the laws, applies to these corporations. We are all of the opinion that it does." So what we had was you couldn't set rates, you couldn't set freight rates, you couldn't tax, Minnesota tried to have, they were being gouged on milk when they transported milk, so they tried, and all of these were struck down on 14th Amendment grounds. Then in 1896 it all came together. The rights of human beings had been disposed of, and the rights of inanimate objects had been upheld, and the confluence was the famous case Plessy versus Ferguson. Plessy versus Ferguson, as most of you know, is the separate but equal decision. It was a test case against the separate car law in Louisiana, which stipulated that blacks and whites did not have to ride, could not ride in the same railroad car, but they would have equal accommodation. The equal accommodation was the whites would ride in the first-class cars toward the back of the train with padded cushions and relatively good accommodations, and the blacks would ride in the car just behind the locomotive, which was constantly filled with smoke, with broken seats, broken windows, and never cleaned. This was the equal accommodations of in the separate car law. Well, in Plessy versus Ferguson, it was another 8-to-1 ruling. Justice Harlan, again the only dissenter. And the court ruled, speaking through Henry Billings Brown, a justice who had been appointed a few years before, that separate but equal is just fine. There is no requirement in the Constitution that races be forced to share accommodations as long as the accommodations available to each one were equal. That the accommodations were clearly not equal, they overlooked. As he had in the civil rights cases, Harlan not only used his opinion to produce one of the nation's great enunciations of individual liberty and racial equality, but he also destroyed the camouflage laid on by Louisiana and accepted by the majority that a law mandating separation of the races wasn't discriminatory, since it applied equally. He wrote, "Everyone knows that the statute in question had its origin in the purpose not so much to exclude white persons from railroad cars occupied by blacks as to exclude colored people from coaches occupied or assigned to white persons." And then, in one of the most famous lines ever to come out of the Supreme Court, Harlan said, "In view of the Constitution in the eye of the law, there is in this country no superior dominant ruling class of citizens. There is no caste here. Our Constitution is colorblind."